of virtual and real presentation during the COVID-19 pandemic. It's nice to be here at the UCLAN faculty, and I'm invited today to give a presentation about populism in the Netherlands before the COVID pandemic and after. What I will do first is to give an overview of the profile of the Netherlands, what are the particularities of the Netherlands country, then move on to the judicial system in the Netherlands, as well as a short overview of the executive and legislative branch of power, and to follow and to continue the presentation with three different kinds of cases. Cases related to hate crimes and populism, cases related to the protection of the environment, and the last one is the cases regarding the measures that the government was taking during the COVID-19 pandemic and is still taking. Now let me start first with the profile of the Netherlands. You'll see on this picture still a happy group of supporters of the football. Unfortunately, we lost some game in the European Championship, so they are now lesser happy. But in general, orange is the color of the Netherlands. We have 17 million inhabitants. It's a constitutional monarchy. We have an open economy, so we do a lot of foreign trades, export. But it's also a multicultural society, and that is represented also in this graph from 1995 till 2019, how the numbers are growing with regards to the immigration of people in the Netherlands. And that graph is also important for the context of one of the cases that I will present, because that will be about immigration and hate crimes. In the Netherlands, like in many other countries, we have a three-layered court system. At the lowest level, we have 11 district courts or courts of first instance with civil departments, criminal departments, and administrative departments, 5 courts of appeal, and the Supreme Court. Besides the ordinary court system, we have also specialized administrative appeal courts, and at the highest level we have the Council of State. The Council of State is in fact has two roles. One is an advisory body, like in France, as the Conseil d'État for legislative matters, law proposals, and on the other side we have the administrative appeal chamber, and they are the highest court for immigration law cases, spatial law cases, and environmental law cases. Now, about this Council of State, there are always disputes, because the judges that are working in this administrative tribunal, they are not professional judges. They are, in fact, former ministers, high-ranking civil servants, former high-ranking civil servants. So they are not real judges. And there is always this fear that the advisory tasks of the Council of State is being mixed with the role as a judge. So one side you are a policy advising body, and the other side you can decide on cases that may be related to the same policy. So there is always a debate about should we split the Council of State into an advisory organization and move this court task to, for example, the Supreme Court. We have also a lot of judges for our country, 2,500 judges and 9,000 court staff. And that is quite a luxury, also when I compare it with other countries where, for example, you have much lesser court staff, or even that is only one person assisting the judge. And, yes, 2 weeks ago, last week I was in Albania, and there they have this situation, for example, they have only one court secretary and assisting the judge, so they cannot do preparatory work because they are all week in hearings. And that, of course, gives problems in the functioning of the court system. We are processing 1.4 million cases per year. And what you see, by the way, on the picture on the right-hand side, it's a nice statute, but it's also in front of the new courthouse in the District Court of Amsterdam. So it's a brand new building. Transparent, as you can see. That is also reflected in general in the architecture of the court system in Netherlands. They want to be open and transparent, so that's why you need to have all this glass in the courthouse.
What's the statute about?
The statute about, frankly speaking, I should have researched it, and I really don't know what's the statute. But it's, I need to check indeed. Now, I also would like to tell a little bit about the political orientation of the Netherlands judges. And, well, it's already an old survey from 2010, where they have surveyed the judicial candidates studying at the School for the Judiciary, either candidates for courts or prosecutorial candidates. And what you see here is that the majority is from the green. Now I'm going wrong because it's not working. The majority is from the Democratic Party, D66. It's a political party on the center left. And followed by a lot of judges that have a political orientation towards the Labour Party. Social Democrats, left-wing, let's say. Also important to bear in mind, left-wing judges. And to a much lesser extent, the judges are supporting the Liberal Party and the Christian Democrats, but that was in 2010. And I think if you would do the same survey now, it may be completely different, because what you see all in Europe is the liberal parties are gaining more power, the conservative parties, yes?
I just want to ask about this survey. So, is it a matter of the political orientation of the judges being out in the open, as it is in the US, for instance? Or is it more like a survey where you ask judges anonymously without them displaying their
we ask in this survey their political interest, not that they represent political parties, because it's not allowed, according to the law and conflict of interest, to, let's say, to express openly your political feelings towards a certain party. So they're only, let's say, behind closed doors, what they think and would be the right political orientation. So at that time, let's say 2010, these candidates were more or less center left-wing oriented, and now, of course, they all are judges and prosecutors, and it's still in the mindset of certain politicians, which I will come back later as well. Then we have the executive power. This, the red brick building, is the Ministry of Justice and Security. I have worked there a while ago on the 21st floor. It has 36 floors, so you have a beautiful overview on top of this building.
Is it really security? That's surprising. It's a public order or something?
Well, I will tell you a little bit about the history indeed, because 2 governments ago it was simply the Ministry of Justice. And we had the police responsibility in the White Building, the Ministry of Internal Affairs. At a certain moment, the government decided, maybe to follow the British example, to merge the police part into the Ministry of Justice. And then at that time, the Ministry of Security and Justice was established. Now that is also interesting, the Ministry of Security and Justice. Why security first? At that time, the political orientation was focused on prevention of terrorism, fight against crime, and lesser towards justice and protection of human rights and so on. So there was this imbalance. So that's why it was called the Ministry of Security and Justice. Now the latest government reversed that around, and it cost a lot of money, by the way, to change it. So they changed it into the Ministry of Justice and Security. So let's say the current, well, it's not the current minister at the moment because we don't have a government yet. The current Minister of Justice stated that justice is more important. He's a lawyer, and rule of law and human rights, and put the security part to the end to give a different priority. Now, the Minister of Justice and Security is not politically responsible for judiciary. We have established in 2002 a Council for Judiciary with the aim of strengthening of the independence of the judiciary, focusing on budget responsibility, responsibilities in the sphere of human resources, information technology, infrastructure, policy developments, and everything that is related to court administration. So the Council for the Judiciary has its own budget and allocates the budget to the individual courts, with the exception of the Supreme Court. The Supreme Court is a different judicial authority with its own budget and does not fall under the Council for the Judiciary. So the Minister of Justice is not responsible for judiciary. This in contrast with the public prosecution. We have an office of the General Public Prosecutors and regional and local offices of the public prosecution. They are formally hierarchically falling under the Ministry of Justice. And that means in practice that in rare cases, a Minister of Justice can give instructions on concrete criminal cases or influence the criminal policies. Because the Office of the Public Prosecutor General, for example, they define the priorities in criminal policies. For example, every year they do that money laundering is a priority, or cybercrime, human trafficking, and so on. So they define the priorities so that, let's say, the public prosecutors know which cases are more important to prosecute than others, and also to allocate the relevant resources to that. As I said earlier already, the minister is also responsible for the police, and therefore is one of the biggest employers of the government in the Netherlands. 30,000 civil servants are working in the ministry. As I said, in the building, 3,000, outside more. And the only ministry that has more civil servants is the tax authority. But okay, there is also a priority in collecting money, so you need to have a lot of civil servants for that. The legislative power is focused on the second chamber and first chamber in parliaments. The first chamber can only adopt or refuse law proposals. They cannot amend law proposals. The main task of the parliament is to supervise the executive power. They can initiate by themselves new laws. They have the right to amend laws. They have the right to ask critical questions. They have the right to adopt the budget, but also to conduct parliamentary investigations in cases that something seriously went wrong in the executive branch of power. Now, most ideally, we have and we apply the principle of separations of power, trias politica, where each of the powers is independent, the executive, legislative, and judiciary. However, when you look in practice, there are some tensions in this application of the idea of the trias politica. To give an example, this politician that you see on the picture is one of the causes of big problems for the former government and coalition parties. He is a very critical member of parliament, and he found out that there were serious misconducts carried out in the Ministry of Finance, with the tax authority, so that groups of people were labeled as tax evaders, fraudulent people, and they got into serious financial problems. The political leader of the Ministry of Finance, but also the leadership of the tax authority, tried to cover up this incident, but he found out and he started to dig and dig. And that resulted in the fact that after the elections that were held in March this year, there were coalition negotiations, and during these negotiations, one of the negotiators was discovered with a piece of paper saying that this member of parliament, we should get rid from it. Because he's too critical and he's not supporting the party line between the party in government, which was the Christian Democrats, and his party, also Christian Democrats. So it's not a real dualism. And now we have a debate that, listen, we don't want to have that critical parliaments are not allowed to raise their voice. And we need to have a parliament that controls the executive powers, so we should have more of these people instead of less. Now, the other area where you see tensions is in the field of the administrative law, because that is the law which is closest to government policies. And what we see from time to time is that judges are making decisions, try to change the policies of government, so they are going to sit on the governmental seat instead of acting as a judge. And that can be, for example, the case especially in environmental law. So most ideally, we have separations of power principle, but in practice, sometimes there are some tensions in that.
What's the name of this politician?
This member of parliament is Mr. Omtzigt, and he left the Christian Democrat Party, by the way, and he was one of the persons that was very popular, and a lot of people voted for him because he was just one of the activist member of parliament. So now the Christian Democrats have a big problem, because if they would have new elections, all the voters will go to him and not to the Christian Democratic Party anymore, because they don't trust. And even, let's say, they don't trust at the moment the Prime Minister, because the Prime Minister also said that I don't remember that we had a critical conversation about this member of parliament. I do not recall it. It's a standard reaction of politicians. They suddenly get memory loss, and but later they also found some concrete evidence that he did know. And of course that erodes the trust in government and in politicians. And I always say to myself is, I have never met a reliable and trustworthy politician in my life. So I don't know if they do exist. Maybe they are rare persons, but I haven't found them. When you look in an international context on the Netherlands, we are scoring quite good if you take into consideration the rule of law index that has been developed by the World Justice Project. We are ranking out of 128 countries on place number 5. And we score, for example, quite good on the protection of fundamental rights, order security, regulatory enforcement, civil justice, and a little bit lesser on criminal justice. But overall, it's a very good score. And when it comes to the doing business studies from the World Bank, the Netherlands is ranking 42, place 42 out of 190 countries. And that study is mainly focused on how easy it is to start a new business in a country or to close a business, how effective is the regulatory system, what if you have a commercial disputes and so on. So it's an okay ranking, but New Zealand is on top. And the last international comparison that I would like to present is from the World Economic Forum about also the business climate, and we are ranking on place number 4, and number 1 is Singapore. Now, Singapore is an interesting country, by the way. It's a small state. I've been there also a couple of times, and they have a very good functional court system. So the idea is that if you have a very well organized court system, it attracts businesses and therefore contribute positively to economic development. And that's why, for example, in other regions, like in Dubai, they try to copy the same system to have, let's say, a place in the region as number 1 for attracting international businesses. It's only for the civil law case, because if you are looking at the criminal law area and human rights, it's a different story. I will not go into detail of, let's say, the behavior of the Singapore courts in criminal cases, because it's already well known with the death penalty and drug possession and so on. And even if you are an illegal worker from India, for example, you are being caught, you can get physical punishment in the prison, and these are quite severe. It's also, by the way, from the British history, the physical punishment with bamboo sticks, so that they keep still in the region. Now then, I actually come to my main subjects. As I indicated in the introduction, populism can be connected to hate crime and hate crime cases. We have in Article 1 of our Constitution clearly mentioned that every citizen of the Netherlands should be equally treated, and discrimination based on religion, belief, political orientation, race, gender, or any ground is not permitted. So it's clearly mentioned in this non-discrimination in our Constitution. Now today I want to present 2 cases that are connected to discrimination and hate crimes. One case is what I define as the Moroccan case of the right-wing politician Geert Wilders, and the other case is from a Dutch rapper Abbasi, who also committed some discrimination or discriminatory remarks in public, which was not prosecuted. Now let me start with Mr. Wilders. He is seen as the Mozart of the Netherlands because of his hair, and in the past he also colored his hair, not like Donald Trump, but it was blonde and now it's gray. He's party leader of the right-wing party, Party for Freedom, PVV. And he's openly expressing his criticism regarding the large groups of immigrants coming to the Netherlands, destroying the traditional cultural values of our country. And he also had this idea to ban all mosques in the Netherlands, because what you see as a trend in the Netherlands is that more and more Catholic churches are being closed because nobody's going to church anymore. And on the other side, you see mosques are being constructed. sometimes under the influence of Turkey or Qatar, that is financing these expensive buildings, and he's worried about that. In 2004, a terrorist group residing in The Hague committed an attack in the parliamentary building, and they tried to kill Mr. Wilders. And from that time, he is 24/7 under police protection and security protection. He also lives in a safe house with bulletproof windows and so on, already from 2004. So we are talking now 2021. But he didn't stop him to make critical remarks about Muslims or about immigrants. And in 2008, for example, he published this short movie called Fitna. And you can still find it on the internet, but it's a highly controversial movie. And one of the controversial statements that was made in this movie is that the Islam is a retarded or backward religion, and Islamic people are stupid or crazy. And at that time, I remember I had a holiday in Egypt, and I was, all the Muslim countries were very critical after the publication of this video. So I could not even openly express that I was coming from the Netherlands, because then you are seen as some kind of supporter of Mr. Wilders. So that was a very problematic time period. And as a result of that, he received also in 2010 a fatwa, and he was put it on the Al-Qaeda hit list, like many other anti-Muslim people that, for example, criticizing the Prophet of Muhammad. And that it can be already the result that you are being put on a hit list to be killed. So he's still under protection, and he cannot go nowhere without protection. But it don't stop him. It doesn't stop him. On this screen, you see a screenshot of some election rally that took place somewhere in 2014. He publicly made a couple of statements during that election rally. First statement was he didn't like the Social Democrats, so he said, do we want to have lesser or more Social Democrats? No, we want to have lesser Social Democrats. Okay. He's anti-European Union. So the second statement he made, do we want to have more European Union or a lesser European Union? No, we want to have lesser European Union. Of course, because these are, and his political party is anti-European Union. He also promoted the Nexit alongside the Brexit, so that also the Netherlands would leave the European Union because we are spending too much money on southern European countries that are too lazy and wasting our money, and then we have to pay for everything. So we want to. The last statement that he was making was about Moroccans. Do we want to have more Moroccans in the Netherlands or less Moroccans in the Netherlands? And of course, his supporters shouted, we want to have lesser Moroccans in our country. Why? Why did he make this statement? Because it is shown that, let's say, that we have a lot of criminals amongst the group of Moroccans. And they are active in the drug sphere, organized crime. They have a lot of contract killing in the Amsterdam region carried out. So there is a problem with a specific category of immigrants, but not, of course, with all Moroccans. And that statement was the reason that in the period 2016 till 2020, a case was initiated, a criminal case on an acting member of parliament. And that is quite unique. It doesn't happen that much. And the public prosecutor indicated that why he's being prosecuted is the fact that he's making a statement in general about Moroccans, not towards a specific group of Moroccans, the criminal category. As a result of the remarks that he made on television, approximately 6,000 people reported this to the police, that it is discrimination. The police the prosecution demanded a fine of 5,000 euros. And of course, Mr. Wilders don't accept this fine. So they went to court. And his main argumentation in the court was that I have freedom of speech. It's mentioned in the decisions and the articles of the European Court of Human Rights, Article 10, freedom of speech, I can say whatever I want. The district court, however, convicted him for group insults and inciting to discrimination of Moroccans in the Netherlands. So they did not go along with the line of reasoning of Mr. Wilders, but they said, yeah, he committed a criminal offense. And of course, during this procedure in first instance, but also in appeal, he said, this process is political oriented and motivated. I'm not receiving a right to a fair trial. Why? You remember the statistics about the political orientation of the judicial candidates. Why? Because all these judges are left-wing oriented judges, and they cannot decide independently on me because they have already their political orientation ready, and I don't accept it. So he also attempted many times to try to annul the presence of certain judges, but they failed. And for that reason, also he went into appeal at the appeal court in The Hague. And during that appeal, there was another interesting revelation in this case. He said, not only the judges are leftish, but the Minister of Justice and the head of the Office of the Public Prosecutor intervened in my case. And the former Minister of Justice was from the Liberal Party. In the past, they tried to create a government with the Liberal Party, and Mr. Wilders, they did not accept his political ideas, so it never worked out. So there was always this kind of enemy relationship between the Liberal Party and Mr. Wilders. And he said, yeah, well, this Minister of Justice is influencing my case. Not openly, but maybe through meetings with civil servants, top civil servants, and the Office of the General Public Prosecutor, and I don't get a fair trial. But also in appeal, the judges argued that they didn't find any strong evidence of this political interference in the Wilders case. So they sentenced him still. He was convicted for group insult, but without a penalty. And he is released for the accusation of incitement to hate or discrimination. It was a long process. 4 years. 4 years to try this case, and of course it was a highly visible and high-profile case in the courts. Now then I would like to give you another example, a totally different example. This guy, born in 1998, is some kind of rapper. I've never heard from him, but he's a rapper, makes some music. But he also don't like discrimination. So in the period 2009-2030, he released a couple of tweet messages. Okay, they are here presented in Dutch, because the tweets were in Dutch. And it's about a traditional children celebration that every year takes place on the 5th of September, Sint Nicholas. And St. Nicholas is a Catholic holy person coming from Spain with the boats, together with his assistants, black men, to give the children's candies and presents. But it's about the black men. And these black men, he said, they must be dead, black men, or I will shoot them to death. If I see them on the street, I will kill them. And just to give you an indication how they look like this. So you have St. Nicholas and the black men. It's a 200 years old tradition, or maybe even longer. And the idea was that these black men became black because they had to climb in the chimney of houses to bring presents. And since these chimneys are dirty and so on, they become black. Later on, let's say over the last years with the development of Black Lives Matter and so on movement, they identify the black men as slaves. And the Netherlands don't have a very nice history when it comes to the slave trade of the East Indian Company. They traded African slaves to become slaves in the United States to work there. And they said these black men are not people that climbed in the chimneys. No, they were former slaves. So in 2020, he spoke openly at a protest meeting, Black Lives Matter meeting in Amsterdam in front of 50,000 spectators. And he made this statement that at the moment, if I will see black men Pete in November, I will kick him personally in the face. Similar, but to a lesser extent, some citizens decided to report this case at the police as a crime. According to the prosecution, the statement was indeed inflammatory and is promoting the idea of committing a criminal offense, namely the physical abuse of a person, in this case, black man Pete. However, he was arrested in 2020 and interviewed by the public prosecutor, but the public prosecutor decided to dismiss the case. It's not a hate crime, under the condition that if he would make the same kind of statements within 1 year, he will be prosecuted. Now, a certain group of citizens were not satisfied with the fact that we have this opportunity principle in the Netherlands of that prosecutors can decide to drop a case. There is also the possibility to file a complaint and to force the public prosecutor to reopen the case. You have to go to the Court of Appeal. It's Article 12 procedure in the criminal code. And these groups of citizens said, you need to prosecute this case because it's discrimination. And what is the difference between this case and the case of Mr. Wilders? It's a thin line. However, the Court of Appeal decided to dismiss the case and not to prosecute because there was this condition already provided by the public prosecutor. If you commit the same offense within 1 year, you will be prosecuted. But of course, certain groups in society are not happy about it. Why also? Because the media found out at a later stage that the public prosecutor that was deciding on the case was also a member of the board of an anti-discrimination group.
But that wasn't disclosed at the time?
It was not disclosed at that time. Later, the Prosecutor General's office discovered this, and they were quite embarrassed about it. Listen, this is conflict of interest, that you have here a prosecutor that probably promotes Black Lives Matter thing, and also this anti-St. Nicholas celebration. So this prosecutor is not independent. But still, the Court of Appeal decided not to prosecute. It's an interesting question. Is it fair compared to the other case where the politician was discriminating and this person was not being prosecuted? I don't know. is, of course, if I would connect it to Cyprus, if you have also hate crime cases, and how many and what kind of hate crime cases you have in court, and how they are being dealt with. I don't know, but maybe you can give some insight on that. If there are maybe hate crime cases against the Turks, or hate crime cases against also immigrants that are coming with boats here, and they are being pushed back in the sea. I don't know. Are there cases?
I'm not the right person. You know?
I'm not the right person, but I don't think that there are cases against Turkish Cypriots. I don't think that there are any cases of the sort. Because of the history of Cyprus, the targets would be different, right? So,
yeah.
In the case of the Netherlands, of course, being a colonial power, targets would also include black people, but in Cyprus, targets would be different. I would expect immigrants to be a target. And I know that we have parties in Cyprus that promote anti-immigrant action, right? But I don't think, I might be mistaken, but I don't think that this has been reported.
Yeah, we have a weaker framework here, much weaker than what you described in the first place. But I wanted to come back to, so I'm going to get closer to my microphone,
yes.
Otherwise people come here. But I wanted to come back to the two cases that you described. So the two, the two factors that I can see perhaps playing a role is the fact that on the one hand you have a politician, on the other you have a rapper. I'm not sure whether he's a public figure, but from what you're saying, he became a public figure thanks to this, actually.
Yeah.
Okay, that's the first thing. So probably, you know, the duties and expectations on that person were not the same, obviously. And the second thing is, actually, that black man pit does not exist.
Wow, it's, let's say, imaginative.
Yes. So maybe this is also to be taken into account, or was taken into account, that it was more of a, you know, it's more of a tale or a traditional figure.
Yes, you can say so, but on the other side, let's say the Dutch citizens have struggled with this issue, and that resulted in some kind of intermediate solution with regards to this black man piece. So they had, there is a group in society, especially with the African background, they say it's from slavery. So what they have done, because this protest over the year was growing against this type of persons, is they changed the color in the face. So they made a gray piece, so they gray face, or they make a rainbow piece with rainbow colors,
okay,
something different, not to be connected anymore with the slave history. But again, to my opinion, it was not related. If you go into the history of this black man piece, it's not related to slavery, but it was like this story of going, climbing in the chimney, becoming black.
But I mean, I guess it's a similar debate to what they have in the US with blackface, right? So the idea here with black man is, as you explained, yes, of course, it's not supposed to represent a slave, but the sheer appearance of a person wearing a blackface would play on certain stereotypes and would probably make some people feel discriminated and so on and so on. So I guess that's why the symbolic change of putting a rainbow would probably indeed make a difference.
Yes, but I don't know, I'm not 100% sure now if with this anti-LGBT whatever movement that they say, oh, now this rainbow represents some groups in society that
what
we
about orange color?
I mean, of course, the question becomes, what about reclaiming something? Right? So in the case of putting the rainbow color, that would be seen as a positive representation of the LGBT community instead of the negative representation.
but then there might be others in society inspired to protest against this call, say, like in Hungary or in Poland or Slovenia. We don't want to have that. We don't want to have even rainbows on faces.
One final question. Did anything happen to the public prosecutor who was involved?
No, nothing happened.
That's a problem.
Maybe behind closed doors.
Okay.
That they had some conversation about, but it can also be that it was a decision of the chief prosecutor or the head prosecutor to allocate the case to this person. And but to my opinion, she should have disclosed this specific relationship with this anti-discrimination movement, because it influenced your decision-making process. And well, I'm not sure if some disciplinary measures have been taken against this public prosecutor, because that is not disclosed.
I have a question related to that.
Yeah.
Right? So I agree with you that it should have been disclosed, right? Because it's important in terms of the rule of law that judicial independence is also seen, not simply practiced, right? So I agree with you on that. My question is, do you think that the fact that the decision to not prosecute was also subject to a review by the court make a difference here? So as I understand it, the prosecutor decided not to prosecute, and then that decision was reviewed by a separate panel of judges that supposedly do not share the same.
So, and their line of reasoning was, and that was not disclosed to the wider public and the media, I think, that the decision not to prosecute this person was made under a certain condition. That if you, within 1 year, you make again this kind of crazy statements, you will be prosecuted. And that was not clearly published in the media, and that resulted in some outrage to certain groups of society, because the Netherlands citizens are a tolerant group of people. But sometimes, they feel that their norms and values, the traditional norms and values, are becoming under pressure. Where, for example, this celebration of St. Nicholas should not be allowed anymore, because there is a group of Islamic citizens that see this as a religious celebration, and we don't want that. The same with the slave history. So the Netherlands is always struggling with the slave history, and therefore very careful when it comes to discriminating remarks or towards certain groups in society. But there are protest organizations, of course, inspired, for example, by Black Lives Matter, that becomes active to protest and put the slave history on the agenda again. And they use, for example, this St. Nicholas celebration as an argument to put it on the agenda. I don't know what is right and what is wrong, but at least it is nice to controversing cases.
But people are seeing things from a specific point of view, but when it comes to Catholic people, they are as well being discriminated. So isn't this a discrimination, a massive discrimination for the Catholic people to stop celebrating St. Nicholas? So
yes.
Why taking the argument only from one side? There's both sides, that everyone must be equal and have freedom. Not limiting one party just to maybe give more power to the other party.
It's an interesting question, but it's something that, let's say, the original Dutch people are maybe not so protest-minded in these discrimination cases. But it's also gives certain problems in society. Just to give you an example, we have this Article 1 in the Constitution. Everybody should be treated equally, and you have the right to freedom of religion. Now, if you look at the education system in the Netherlands, we have public schools, but we have also from history Catholic schools or Protestant schools. And that was one of the reasons that we have this specific article of freedom of religion, so that these groups in society, they can create their schools. But it became a problem when Islamic citizens started to establish Islamic schools in the Netherlands. And these Islamic schools are not, let's say, always promoting peaceful values, like the Salafist groups. They are more in favor of, let's say, killing the Catholics and so on. They are explaining, inciting violence towards other religious groups, not being tolerant. And so there were cases where they, in fact, discovered this in certain Islamic schools in the Netherlands, and they want to close these schools. But how to close the schools if you have in Article 1 in the Constitution that you have freedom of religion? So it's a big problem, and I would say also a legal problem. How to, maybe there will be an exception article in this to be introduced in the future on the Constitution. But this is where society at the moment is struggling with. The second group of cases that I would like to explain is not about discrimination, but it's about another important issue, protection of the environment and climate. And we have two interesting cases that has been decided upon in the Netherlands. One is what is defined as the Regenda case. And the second one is a very recent one, is the case of Shell against environmental groups. And I would like to explain you a little bit the context of these cases, because they can be of importance also for other EU member states. Now let me start with this Regenda case. In 2012, this association, this environmental group, they sent a letter to the Netherlands government urging to take measures with regards global warming and reducing carbon dioxide by the industry, but also due to the use of cars and so on. And nothing happened. The government say, okay, we are, it is a Paris Agreement, and we are following this agreement, but the implementation of the agreement takes a lot of time. So not much measures has been undertaken. So they initiated in 2015 a case against the government. In May, October, they lodged an appeal, and in 2019, there was a decision taken by the Supreme Court. So this case was quite long, 7 years of, let's say, from the moment that a letter was sent to the government till the final decision of the Supreme Court. Now, who is this association Regenda? Regenda is in fact a foundation that is focusing on the promotion of renewable energy and to make a transition where you have a climate, environmental friendly country with energy neutral houses and also the use of electrical cars, for example. And they are of opinion that climate change is one of the biggest challenges, and we should look for solutions to protect the world for future generations. Now, Regenda decided to initiate this case at the district court, and they said this carbon dioxide is a big problem, and it harms people, and it must be radically reduced. And they think, and they are of opinion, that the Dutch state is required to take measures to radically reduce the greenhouse effect. In 2015, the district court in The Hague ordered the state, in fact, to take actively the measures so that the CO2 levels would be reduced by 25% in the year 2020 compared to 1990. So they obliged the state to take actively measures because the government did not took measures, and the judge decided, yeah, listen, it's enough, you have to take measures. And what was the reasoning? You can find it also in the decision of the Court of Appeal in 2008, where clearly they made a link with the protection of the human rights. So the judges decided in this decision of the Court of Appeal that there are dangers and there should be measures taken to protect the life and family of citizens in the Netherlands. And the Court of Appeal is of opinion that the ruling gives the state the legal duty to ensure the protection of the life and family of citizens, also in the long term, which is enshrined in the European Convention on Human Rights.
So, Pim, the Dutch government had appealed.
The Dutch government has appealed against this decision. Yes.
And how did the district court suggest the Dutch state actually take action? Were there indications in the judgment?
There were indications in the judgment. In fact, they, in their decision, mentioned the target of 25% reduction. And also already in their line of reasoning, they connected the responsibility of the state with the protection of human rights. So that if you are not responsible as a state to take measures to reduce the carbon dioxide levels, you are violating the human rights of citizens.
So on what grounds did the Dutch government appeal? What was their line of reasoning?
The line of reasoning probably was that they were not capable to realize this 25% reduction.
Not that the court was not competent.
No. That was not the reason, because then also the government would not have a nice picture in the media that said, okay, you're not a competent court, whatever. No, there is this administrative law department in district courts that are responsible for the disputes, let's say, from citizens against the state. So they are competent, but they were not agreeing about the speed of reduction of this carbon dioxide level. They said it's impossible, we cannot do that, we need to have agreement with companies, we need to make the transition from traditional cars to electrical cars and so on. So we're also following this Paris Agreement, which is having a lower target. I don't know the exact details, but maybe a lower target for 2020. So we follow this line of reasoning and not the reasoning of the district courts. But the district court did not went along with it. Probably an activist judge, again reminding we have these social democrat judges centered to the left that are, let's say, more critical against governments that are governed by liberal parties that are promoting, let's say, businesses, industry, and so on. And the leftist judges, we don't know, of course, but maybe in the head of mind, they are more focused on protecting the citizens against corporations that are polluting. So, but it's interesting that in the decision of the Court of Appeal, this connection was made with the protection of European Court of Human Rights. Again, the government was not agreeing with the interpretation of the law, and they went to the Supreme Court. And the Supreme Court decided, and here you see the victory of the lawyers and this Regenda group in the picture. The Supreme Court said you should uphold the decision of the Court of Appeal. There is clearly a link between air pollution and the protection of human rights, and you as a government have an individual responsibility to protect it. Now later I will want to have a discussion about how it is working in Cyprus, because it's very interesting. I have my own opinion about it, but that I will leave after the second case. And that is a more recent one. And it's a groundbreaking case, I would say so. Because in 2019, a group of climate organizations and citizens, 17,000 citizens, started a case against Shell Oil Company with regards to their air polluting behavior. Well, what you see on the picture is a oil refinery. And a long time ago, I have lived not far away from this refinery. In the night, it looks very nice with all these lights, but you feel a lot of air pollution and so on. So it's not, let's say, a nice environment to grow up with children and so on. Frankly speaking, it's terrible. So
Where is this located in the Netherlands?
It's called Pernis. It's a place that is, yeah, it's almost Rotterdam.
Okay.
But it's having one of the largest oil refineries in Europe. And you see here this one that makes a lot of air pollution. I saw it always, and it's stinky and whatever. So you know that it was not good. And even had once a small side job on this refinery. And okay, if you're walking there, you smell it, you know that it's not okay. But at a certain moment, you don't smell it anymore because you're every day in this smell. Now, this environmental group made a claim that the Shell company is not sufficiently taking measures to reduce carbon dioxide of the factories in the Netherlands. And same like this Regenda case, they urged Shell companies to reduce the carbon dioxide levels in 2030 so that it is more or less the same level as it was in 2019, and in 2019 it was already pretty bad, so it's not, let's say, a major improvement, but it would have resulted in a reduction with CO2 with 45%. Now, to put this in a context, the protest organization made also some research about facts. And the fact is that Shell company is emitting 9 times more CO2 per year than the whole emission in the Netherlands. So it's quite a lot, 9 times more of a whole country. And on the other side, they have a powerful lobby group, like many other companies has in Brussels and the European Commission, to block, let's say, certain proposals that are not of interest in the companies. And so they spent, over the last 9 years, apparently 215 million euros to block initiatives of the European Commission and the European Parliament that was focused on improving the environment. And only 4% of the investment that they make of these companies allocated to renewable and sustainable energy. So they're investing a little bit in solar energy, and now they make some transition also in the field of electricity. So if you go to gas stations, Shell gas stations in the Netherlands, you find also more and more possibilities to charge your car, electrical car, in these gas stations, which I cannot find here in Cyprus, for example. There's no place where you can charge your electrical car. But we will come back to that later when we discuss the Cyprus situation, because I think there are many interesting, yes, many interesting, let's say, measures that should have been taken to protect the environment on this island. Well, in May, there was a groundbreaking decision of the District Court of The Hague. And the judges of and here you see the victory on the stairs of the District Court of the protest organization. So they are very happy about it. They said, the judges indicated that Shell company is the largest producer of fuel in the world, and the CO2 emissions are even larger than many other countries. And that it contributes to global warming, resulting in a dangerous climate change, and that can have also severe risk, again, to the protection of human rights of citizens. So also this judge said, yeah, you cannot continue like this because you are violating the rights of citizens, and especially of children and other generations that will come after you. And if you have destroyed already the world, yeah, you cannot fix it. So companies like Shell should respect human rights, and that's not only a responsibility of the state in the Regenda case, but it's also an individual responsibility of the Shell company as well. And therefore, in this decision, the court ordered the Shell company to reduce its emission with 45% in the year 2030. And that is really a groundbreaking decision. This decision has not been taken elsewhere in the world. And many global companies, oil companies, have carefully followed this decision because it is accepted, and they made the link that companies have a social responsibility. They cannot pollute the earth forever. They have also to respect the human rights of citizens. The company itself, Shell company, is still considering of going in appeal, but on the other side they remain silent because they are carefully balancing their, let's say, public orientation. Because if they go in appeal, they can get a worse reputation, not a better reputation. And British Petrol, for example, Unilever and others are examining this decision because also they are having industry that are polluting the environment. So this is, to my opinion, interesting because in the environmental cases, apparently we have activistic judges that are not afraid to make tough decisions against the state, tough decisions against big companies. And to my opinion, they should be awarded for that. Now I would like to hear indeed, what about Cyprus? I know that we have this, I think, Climate 2000 program or whatever it is, with protection of certain areas here in Cyprus. And I know also the lack of innovation in renewable energy with solar panels. I think that there is a lot of sunshine in Cyprus, but there is some monopoly of an electricity company on this island that is not promoting this, and why there are no cases.
Okay, I'll share with you what I know, what I have researched, what I have experienced. There are no cases at court, or very few cases at court in Cyprus, because of the fact that citizens don't have access to justice in such cases. It's very simple. The local standard in Cyprus for environmental cases is extremely restrictive. Citizens groups or civil society groups do not have the right to basically demonstrate their legitimate interest to proceed. And this is actually in violation of the Aarhus Convention. So we had a whole workshop about this in February 21, whereby we managed to invite the EU level. So there was a judge from the ECJ, the Cypriot judge to the ECJ. There was also a Greek legal counsel to the Republic of Greece in issues, environmental issues. And there was a lady who heads one of the NGOs in Cyprus. So there are quite a few NGOs. This lady, she heads the Laona Foundation, which is based in Limassol, and they look a lot at agamas, for example. But you know, there is equivalent Terra Santa. There are quite a few quite a few NGOs. So we discussed the implementation of the Aarhus Convention into EU law, because there are instruments of secondary legislation implementing the Aarhus Convention, and this is to be noted. That is one of the few areas where actually an instrument of international law has been given legal force in the EU, through, of course, instruments of secondary legislation. We discussed the case law of the court, because there is case law at the CJ level that is actually very helpful for Cyprus. We discussed the French approach, because the French approach is actually a model. I suppose that the Dutch approach is now going to become a very interesting model to study. The French approach is very interesting because in France there is a citizens' charter for the environment. That's the reason why we discussed this, and whether we try to draw conclusions as to what could be improved in Cyprus. At that webinar, there were quite a few judges. They were the main target groups. So we are hoping that this is going to make a small difference, but the main problem is local standard. So at the moment, the main tool against, or let's say to put Cyprus into, into the right direction is the European Commission.
Yeah, that's an interesting one, because I have the feeling, but it's my personal experience, let's say, that a lot of EU directives are not being implemented on time.
Of course.
Not at all in Cyprus.
Correct. So that's why I'm saying the European Commission is the solution.
Only with the wallet.
It's the sort of hope, especially in terms of environmental matters. Only a couple of weeks ago, again, proceedings have been starting against Cyprus on environmental issues. And I can find now, but it's very regular thing. The other thing I wanted to add, when you were showing the picture of the refinery, we have similar issues in Cyprus. So, for example, in the area where I live, which is a beautiful green area, we are surrounded by factories in the wider area. And there is a group of citizens in my area who has taken it into their hands to do something about it. It's been 2-3 years that they are extremely active. We took actions at school and so on and so forth to highlight the fact that you cannot have, poor air quality and a school sat in the middle, for example, and so on. They are finding it incredibly difficult to gain access to justice. So, and I have explained to them quite a few things. In the end, the group, I told them we need a lawyer, a specialized lawyer in environmental protection. This is not, this is not simple. We need an administrative law expert and so on. Even the President of the Republic actually promised that at least the most polluting factory will move. That was last summer, a year ago.
And there was this asphalt factory? Or
this is it. There's the asphalt factory. So it's us. But nothing happened. Why nothing happened? Well, because no one wants that factory on the island. So if you're going to move it from our community, where will you take it? You go to another community, obviously. So the citizens of the other communities who were sort of pre-selected to welcome the factory, they also demonstrated and they also made noise.
It's called the NIMBY policy, not in my backyard.
Not in my backyard, exactly. So
you can move it, but not to our place.
Exactly. So there is no political will.
Yeah.
And there is no real, plan. You need an action plan. And you need it within the context of sustainable development and renewable energies. Otherwise, how can you solve the problem?
But does Cyprus have, for example, a Ministry of Environment?
No.
Okay.
No, we don't have a
Here
Ministry
you go.
of Environment.
Let's say
So,
one of the first steps that can be done to put it higher on the agenda, that can be a president or a prime minister also decide, oh, listen, we are going to take the environment seriously.
Yeah.
We're going to establish a Ministry of Environment, and one of these tasks will be to promote renewable energy, but also to, let's say, prosecute criminal environment and environmental crime.
So, if I'm not mistaken here, but Andreas can correct me, I think it's under the Ministry of Agriculture, Environment. I think so. But they could create a deputy ministry, the way they created one for shipping, tourism, and lately we have a new deputy ministry, I can't remember, from 2 weeks ago. So that's one thing. The other thing that I wanted to mention perhaps is the SDGs. You know, the Sustainable Development Goals here seem to be completely underdeveloped. We are, for example, here at the university, we are members of, you know, huge networks of SDG organizations and so on. However, there seems to be a little bit of movement lately, because this week and last week we had some sort of focus groups among NGOs, higher education institutions from the government, asking us to reflect on some of the SDGs. And of course, governance was high on the agenda, social inclusion was high on the agenda, but also sustainable development and protection of the environment came to the fore. So this is also one way to put pressure on Cyprus, which is the SDGs, and here we go, you know, into another set of tools and rules.
Since the issue is based here on the British system, there is also no tradition of administrative law and administrative courts, right?
Here there is, of course. Yes. So the legal system in Cyprus is actually not really based on the English legal system or the British legal system. The legal system in Cyprus is a mixture of historical events and historical influences. So, of course, we have common law, and this is largely due to you know, British times, but we also have administrative law that comes from Greece and France, and we also have Ottoman law in the form of property law in particular. So we have a mixture of a lot of different influences, which means that administrative law here is very strong. And there is now an administrative court. There wasn't before. A few years ago, there was no administrative court. The Supreme Court in Cyprus was doing everything. Constitutional issues, administrative issues, appeal issues. So now the jurisdictions of the Supreme Court slowly are being spread. It's a huge reform of the judicial system that is currently ongoing, but we have changed 3 ministers of justice in the past 2 years. So how are you going to have an ongoing reform if you know, you keep changing? So yeah, administrative law, as I said before, is a real body of rules and regulations, but it's limited. Think about the local standard issue. It's an administrative law.
I understand, because besides of this factory, you have other issues with
of course.
This Nature 2000 projects, I think, that are constantly under pressure. Some people try to destroy the nature. Then you have the power of the developers that are constructing villas and so on.
Yeah.
In my area, I have the famous Sun City project. So it's where the Giovanni developer decided to put 2 extra floors on the building, and it was squashed by the first instance court apparently, but now it's in appeal. So we have this nice construction. I would like to paint it with corruption or whatever, as a symbol of local corruption. But these processes are going so slowly, and there's no strong power to go against this kind of development. It's all in the interest of the local industry, project developers, that goes against this nature protection or promotion, even a more environmental friendly use of energy. I'm still surprised that in a country like Cyprus, why not have every house, besides of the heating of the water, solar panels on the roof? They have so much sun.
That is the first thing I also said when I came here so many years ago. I said the same thing.
Yeah.
Over 20 years ago. Doesn't make sense.
But I also know that some changes are going slow in this country. You have to be patient.
Okay, I didn't want to mention corruption, but since you mentioned it, we can discuss a little bit corruption. we can say a few words about the main financial machine that was actually supporting in the past years real estate development, which was the passport scheme, the golden passports, so-called golden passports. In other words, investors would get in return for their high investments citizenship, simple citizenship, and as a result, EU citizenship. So that scheme came to an end late last year under pressure, under political pressure. The European Commission has started in October last year, the first step of proceedings against not only Cyprus but also Malta. The European Commission starting step 2 of the process a few weeks ago, so it's not dropping it. The scheme is actually, as I said, terminated. There was a commission of inquiry appointed by the Attorney General of the Republic of Cyprus, who is an independent organ of the state. Okay, the Attorney General, he's not under the Ministry of Justice. So he appointed it was a he at that time, appointed the Commission of Inquiry that started work in early September 2020, and they gave their report a couple of weeks ago. I think it was 7th of June 2021. So I have to disclose that I was helping them for EU law matters. To be honest, I haven't read yet the full report. It's huge. I think it's over 700 pages. But the bottom line is that more than half of the citizenships granted were granted illegally. This is the bottom line.
Which I'm not surprised of.
For a number of reasons. I mean, there were lots of different reasons, but mainly the processes that were in place at different times, because of course this scheme has been in existence for many years. So the processes that were in place were either insufficient, weak, or not followed. And there are allegations of corruption that are linked to the scheme. You probably already know, you mentioned Giovanni, you probably already know that actually the President of the House of Parliament last year had to resign out of, as a result of some bad publicity, and Al Jazeera video, which I think everybody has seen.
Yeah.
Not only, I mean, an MP has also had to resign, and a lawyer was exposed as well. So these are serious stuff. Obviously, a lawyer is responsible and is under, a code of conduct. The MPs are also accountable under a code of conduct, which is newly created, by the way, because that was missing in Cyprus. So if you go back to the Greco round of monitoring of Cyprus, which is ongoing, you can find a lot of very helpful, useful information about recommendations that are being made to the 3 branches of power in the Republic of Cyprus. It would seem that whereas for the judiciary, most of the recommendations are being worked on, for the parliament, it's not the case. Yeah. So the code of conduct, yes, that is apparently done now, but there are many other recommendations, and they are all aimed at fighting corruption.
Yeah.
So here we are.
Here we are indeed. And okay, Greco published its report, but they're not always that strong. I have worked in the Council of Europe, and sometimes these reports are being discussed in the Committee of Ministers. I remember once I observed a Greco report from Russia. And if you know, for example, that Russia is one of the biggest donors for financing the Council of Europe, you say, a Greco report can be critical with regards to corruption or whatever, but you're not going to say any word about it. Even when I worked on these reports on European judicial systems from this European Commission of Efficiency of Justice, I inserted somewhere a graph about the number of cases arriving at the European Court of Human Rights per country, per member state. And there was, of course, at that time, I'm talking about long years ago, it was quite visible that most of the cases were from Russia. And the Russian representatives clearly indicated to me, you are going to take out this graphic from the report. And it happened. So, let's say I have sometimes lesser hope, but let's say with the European Commission more hope because they have money. And with, let's say, the COVID support funding, you can now make conditions. You say, you are getting this money, but you have to do these kind of reforms, otherwise you won't get them. And that is, with regards governments and politicians, the most strongest instrument that you can use, money. The last, but not least interesting topic that I would like to discuss is the COVID-19 measures taken by governments. And this case is about an association which is called Viruswaarheid. It's in Dutch, the truth about the virus. Before it was having the name of Virus Madness, so they changed the name from Virus Madness to Virus Truth. And they initiated cases against the state regarding the evening curfew, against the National Health Institution that is responsible for the projection of COVID-19 cases, and also the limitation of movement, cases against the wearing of face masks, and case against the mandatory use of PCR tests. So, this Viruswaarheid is a Dutch association, and they claim to protect the democratic rule of law principles. And they are stating that due to these measures that the governments are taking, the freedom of expression, opinion, and basic rights of citizens are under pressure. And the main focus of the association is to start many cases about these COVID-19 measures taken by the states and bring them to court. They also do research and provide information, and as you see here, I put it in bracket because it's not scientific research, it's very colored research, and also the information is quite biased. And of course, they use very actively the social media. And similar like here and in many other countries, they are questioning, let's say, the effect of the vaccines, and maybe some chip will be put in your body and whatever. And it's also supported by a certain right-wing association. Here you see another right-wing politician that made a poster for memory of the liberation of the Netherlands in the Second World War. And he claims that, let's say, the freedom of the Netherlands country ended on the 5th of May last year. And this poster is normally used for celebration, so it was very provocative because it's mentioned 1945 and it ends at 2022. So it made a lot of people upset. How can you dare to use this poster and how to connect it with the Second World War? But it's in line with this protest association. In the Netherlands, they did not remain silent with regards to the social distancing measures and the limitation of movements. And they started protest groups, and under the umbrella of, we should have a drink of a cup of coffee near the Museum Square in Amsterdam. So let's have a drink of cup of coffee at the Museum Square in Amsterdam. And this protest group was growing and growing, and probably you have also seen that in the media. It resulted in quite a lot of clashes between the police and the protesters, violent clashes, I would say, so that people were hit and beaten with sticks and so on, that you say, are these measures in proportion of the right to protest? And of course the mayors would say, yeah, this is it's a public health issue and you're not allowed here to protest with so many people. But yeah, this was the climate, let's say 6 months ago in the Netherlands. The association also helped with legal assistance to support people that received fines for violating the corona rules. Interesting in this context, by the way, in the past this fine was around 400 euros for violating the social distancing rules or using of masks. And the height of the fine was that high that you were also registered in the criminal register. So that is something serious, because if you're being registered in the criminal register, if you apply for a job, you need to have a certificate of good conduct, and then it shows, yeah, listen, you are a criminal offender. At a certain moment, the Minister of Justice and Security decided to abolish this rule. Why? Last year, the Minister of Justice and Security got married. And there were pictures taken on this wedding party.
During COVID.
During COVID. There were pictures taken where they were shaking hands or kissing and whatever. And the media found out and they published it in the newspaper. Said, listen, we have to follow the social distancing rules. But what about the minister?
Didn't he resign?
He did not resign. He changed the law so that he paid also the fines, but he changed the law saying that if you committed this offense, you will not be registered in the criminal register. Because he would be the first Minister of Justice to be registered in the criminal register. Okay, he has the power to change it.
And no one called for his resignation? No one called for his resignation?
I don't know. I think, that, well, why they didn't call for the legislation, then I have to come back to this principle of separations of powers and the lack of dualism. Let's say the majority of the political parties in parliament were the parties that were in government. So even the other political parties urged that this minister would resign, they would not get any support because the majority was supporting the government. And that is the only reason. So this is, let's say, this lack of dualism that it's not always functioning in the Netherlands. They also initiated a procedure about this vaccination passport. Already earlier, they say, yeah, listen, you should not be forced to be vaccinated, and you are now limited in your movements. When you're traveling, apparently you need to have a vaccination passport. What is it? Successfully, they had in the past also the cases against the use of PCR test. And about this management outbreak team that was making decisions about social distancing, the evening curfew, closing of businesses and so on. But let me focus on one case, and that was related to the evening curfew. Like in Cyprus, evening curfew was initiated between 8 o'clock in the evening and 6 o'clock in the morning. And Dutch citizens found it as some kind of violation of rights, freedom of movement, why we should have this curfew. The agency that was responsible for collecting information about the COVID infections, they indicated, yeah, it's absolutely necessary to have this curfew because it will reduce the risk of the spread of the virus with 12% or something like that. So that was the argumentation of the institute. This association, however, they said, yeah, we are being limited in our fundamental rights, and the measures that you are now taking, we have only seen that during the Second World War. It's not acceptable because we like to fight and protest in our country. The district court, there was one district court judge who decided, yeah, you're right, you government, you should abolish the curfew and immediately. Why? Because the reasoning of the government was that the curfew was based on an emergency law. very old law that was used, let's say, when we had this problems with water, the flooding of water, and then you need to take immediately emergency measures to protect citizens and so on. So this law, normally related to environmental disasters or something like that, was used for introducing the curfew, and this judge said, well, it's not that emergent that you have to decide immediately to initiate the curfew. You can take maybe other measures as well. So that was, let's say, a small victory of this association, but the victory lasted very shortly, because the government went into appeal, and this appeal, judges, they were more, let's say, in favor of supporting the governmental policies and measures. They said, yeah, this curfew measure is it's a political decision that is based on proportionality and subsidiarity. And also, this Court of Appeal was more conservative. They say, we don't want to be sitting on the chair of the executive power. We are judges, so we just only look formally at the laws. And they said, yeah, this in this specific situation, this emergency law could be applied for the limitation of the movements of people during the curfew. So that is, on one side they had a small victory, on the other side, 2 weeks later, they lost the case. And yeah, what is now developing in many countries is, let's say, this limitation of human rights and even of having your business being forced to be closed, not having sufficient compensation for that. It goes very, very, very deep to the life of citizens. And well, in that context, it's also interesting to see what is the Cypriotic experience in that. I know, of course, I have experienced it also locally, but maybe we can have a conversation about that. And the fact that why there were not so many court cases related to COVID-19 that lawyers here in Cyprus brought before the court. That I'm very surprised of that. Let's say there were protests of people working in hotel business or restaurant owners and so on, but nobody dares to go to court to say, listen, this is too far-reaching, and the measures that you are taking is not, let's say, based on scientific information, because nobody knows in fact how the virus is working and how to limit. So every government is trying to improvise, but how far you should go in taking these governmental measures, and why there are no groups to stop this process. You want to respond, or?
I think maybe
we
this
have
is something we can pick up in the next workshop as well.
I didn't mean to talk about that.
Okay, you can, yeah. But this is my presentation. We can, of course, continue the next workshop about it, but it's something, at least, that comes up to my mind.
I mean, the main reason, or the main, I think, keyword here is delay in justice, here in Cyprus. So there are cases, there have been cases already for interim measures, for example. There are cases that have been filed for, on other grounds and under other procedures, but you show here, between the district court and the court of appeal, 2 weeks passed. And this is to us here. It's
an emergency hearing. Yeah, I know that the court system here is functioning very slowly, and in my opinion, that is used by the government, but also by certain enterprises in Cyprus, the slowness of the system for their own interest. And that's why, to my opinion, also some radical reform of the court system in Cyprus is needed. But that is something that I would give Well, this is what I wanted to say.
Thank you so
And,
much, Pim. That's very,
I hope
very,
it was interesting.
very interesting, very, very interesting. About the emergency law that you presented, this is very interesting because, of course, you spoke about, you know, water overflowing, which for the Netherlands is the biggest threat. We have something similar here. So the measures in Cyprus are taken on the basis of a very old emergency law from colonial times. And there has been a lot of discussion around this as well. And of course, we also have the state of emergency here, but this is not what has been activated for the COVID situation. We're actually using a very old law on emergency measures. So that's one thing that I wanted to say. We have written one blog piece that perhaps we can put in the chat, which is relevant to, actually 2 blog pieces that are relevant to what we just discussed now with Andrea. One of them is from the Verfassung blog in Germany, and the other one is on the rule of law monitoring mechanism. And it actually looks at what you were discussing now, but it's already from last year. But one thing that I wanted to come back to when I was listening to you and looking at the case of Shell, which is incredible. It's a bombshell, really.
It is. It is.
So, especially this idea that, you know, businesses are also responsible for the implementation and the protection of human rights by the side, in parallel to governments. I find that extremely important. And I wanted to see whether the idea of human rights due diligence or rule of law due diligence, which would be applicable to multinationals, for example, but to anyone, is something you have worked on or you have seen in your work being implemented somewhere? That could be good practice?
Not specifically. I would say it's under development that you see now this relationship between the responsibility of companies for protection of human rights. But you see it also in the economical sphere, in the taxation law, that also there's a growing, of course, criticism from society in countries that certain companies are abusing the loopholes in legal systems to maximize their profit. So they maximize profit and they destroy nature. So they have 2 factors that I would say that there is a radical change necessary in the ethical behavior of industries. But I think that also the whole incentive mechanism in terms of receiving money for stocks and so on, there should be some kind of social corporate responsibility built into companies. And that is something that needs to be developed, but maybe it's coming now under the influence of decisions of these environmental cases, and maybe with the abuse of taxation, so that the social awareness comes. Listen, there is a small group in the world that is earning a massive amount of money, and they have no let's say problems with the fact that certain parts of the world are being polluted, because they profit from them at the expense of the whole world, and that should not be acceptable anymore. And I think under the influence of maybe COVID-19, the social responsibility is getting stronger, because people have suffered now so much economically and socially that who benefit the most during the COVID-19 pandemic? The multinationals and the super rich, and the rest is suffering. So there should be some kind of redistribution of fair power and so on.
And not only its maximization of profits and pollution to the environment, but actually it's also quite clearly linked to modern slavery, human trafficking, corruption. So these are much broader pictures and and probably you're right that COVID has sort of exacerbated, people's patience. That's why the idea of, human rights due diligence that would be a compulsory the way we have, risk assessment for privacy. I mean, why only that? Why don't we have an umbrella under which we place all those, compliance and assessments of human rights? We can call it rule of law, we can call it human rights, but we're talking about the same thing, basically.
Yeah.
And make it compulsory, due diligence.
Exactly. Yeah. New topic to be developed.